We are very excited for this evening. We are also very excited for the semester. So if you'd like to get involved with us as a 1L, particularly as a 1L, be sure to email Henry Humphreys. We're going to drop his email in the chat. Mike, if you wouldn't mind doing that, I would greatly appreciate it. We have a lot of exciting stuff going on, including both peer mentors and alumni mentorship programs. And we'll try to also get you guys some merch for members. So all that said, we're excited here and present for the event that we have going on tonight. And Kylie is going to introduce our speakers. Thank you, Kylie.
Hi, everyone. So like Seth said, we're really glad you could join us tonight. I'm really lucky to have Professor Vladeck and Mr. Keller here with us. So I'd like to go ahead and introduce them. Mr. Scott Keller currently chairs Baker Bott's Supreme Court and Constitutional Law practice. He attended Purdue University, where he received his Bachelor of Arts in Political Science and Philosophy, and he then attended Texas Law, graduating in 2007 with highest honors. After law school, Mr. Keller clerked for Judge Kaczynski on the Ninth Circuit and for Justice Anthony Kennedy on the U.S. Supreme Court. He then went on to serve as the Solicitor General of Texas for 3 years, after which he joined Baker Bott's. Mr. Keller has argued 11 cases in front of the U.S. Supreme Court and has been counsel of record on over 90 U.S. Supreme Court briefs, including disputes involving, and it's a long list, regulatory, free speech, immigration, election, criminal, environmental, antitrust, intellectual property, and interstate water issues. Our very own Professor Steve Vladeck is the A. Dalton Cross Professor in Law here at UT and was my con law professor last fall.
I'm sorry.
Shout out to Section 3. We learned a lot. He earned his BA in History and Mathematics from Amherst College and graduated from Yale Law in 2004. After law school, Professor Vladeck clerked on the 9th and 11th circuits. He joined the faculty here in 2016 after 11 years teaching at the University of Miami School of Law and American University Washington College of Law. Professor Vladeck is the co-host, together with Professor Bobby Chesney, of the award-winning and very interesting National Security Law podcast, is CNN Supreme Court analyst and a nationally recognized expert on the federal courts, constitutional law, national security law, and military justice. Professor Vladeck has argued multiple cases before the U.S. Supreme Court and the lower federal courts, has served as an expert witness both in U.S. and foreign tribunals, and has been repeatedly recognized for his influential legal scholarship and teaching. This past term presented some highly controversial and very high-profile cases. Both Mr. Keller and Professor Vladeck are avid court watchers and commentators, and both have outstanding knowledge about and experience in front of the court. And we're all here to listen to them speak, so I will give them the floor. Mr. Keller, you can go ahead and take it away.
Great, appreciate it. Well, thank you very much for the invitation to be here. And Professor Vladeck, it's always good to be doing a Supreme Court term roundup with you. These are obviously interesting times we live in, and that we can't be doing this in person, but very good to see you and appreciate your time here tonight. As far as format goes, I think the more conversational that it's going to be between me and the professor, the better. And that's how we've done it in person in the past, and I think it's worked pretty well. This term, as the last few have been, there's another blockbuster term. I remember it used to be, at least feel like, the ebbs and flows of terms was every term, you'd have one term that was a blockbuster term, you'd have the next term that was a little less hot on the temperature scale, and then it'd go back to a blockbuster term and then one that wasn't. And here we've just had a few in a row that, the hits keep coming. This term, of course, as you know very well, Professor Vladeck, when COVID hit, the court had 2 months worth of cases that it was going to argue, that it only was able to do essentially the equivalent of 1 month, and then other cases got pushed. We can leave it up to guesswork as to which cases were then argued in May versus October, and I imagine the professor may have a few things to say about that. But just from that standpoint, logistically, this was a very abnormal term in the sense that we had the slate of May arguments that were done telephonically in a very different oral argument format than the court is used to doing, and I'm sure we'll get into that a little bit. So even before talking about any of the individual cases, that alone meant this was just a weird term.
Yeah, Scott, I totally agree with that. It was a weird term. I think Scott was alluding to this. I had the very first argument that was postponed. So that was awkward. And now it's been argued in October. It was a weird term, Scott. I think the weirdness shows up in a couple of places, right? So it shows up in the fact that the court decided the fewest argued cases, 53, since 1862, not a typo, right? Since like the Civil War, when there was some other stuff going on, right? It shows up in the fact that the court heard May arguments for the first time in decades, telephonic arguments for the first time ever. The latest we got merits decisions, right, since 1974. And, you know, I was struck by your sort of starting with just how big a term it was. And I think that's absolutely right. All the more remarkable given how few cases they heard. That, you know,
yeah, exactly.
We're so used to saying that like the high profile headline grabbing cases are actually a relatively small percentage of the court's docket. I feel like that wasn't true this term, partly because some of the cases they kicked to October were the less high profile headline grabbing cases from March and April. But the other thing I was going to say, and I suspect that this is another point on which you and I probably agree, is one of the other, partly because of the smaller merits docket, and partly because of COVID, and partly because of just other things unrelated to either of those, it's also been an especially busy term for what Will Bode calls the shadow docket.
Yes.
For the big decisions that are not in argued cases with the fancy hand downs on the Monday, Tuesday, Wednesday mornings at 10 a.m., where you get these pretty important orders, whether it's staying a lower court decision or lifting a lower court stay. And, you know, it's hard to count these because every cert denial is a shadow docket order, right? There are literally 7,000 or 8,000, if not more, shadow docket orders every year. But, you know, just a couple of interesting data points. But we had, so far this term, 11 5-4 shadow docket rulings that we know of, compared to 12 5-4 merits splits. That's a pretty remarkable parity to me. Right, we've seen shadow docket rulings on everything from COVID to Wisconsin and Florida elections, right, to the resumption of the federal death penalty, which produced, you know, 5 really sharply divided 5-4 opinions at 2:30 in the morning on 2 nights, right, last month. So, you know, I guess, you know, Scott, when I look at the term, the first thing I would say is it's not over, right? I mean, we've still got another month of potential action on the shadow docket with COVID and election-related cases. But also just, it's a remarkable term in that it felt like there was never really a break.
And I imagine the justices felt that way. I mean, just, you know, even in the wake right after, I mean, like you said, I mean, you even had, I think had a per curiam opinion or two that were coming out in the week or two right after. So there was not the, okay, all the cases are done and we'll wait to the long conference and, you know, everyone have a good summer. No, it was like immediately right out of the gate, back at it.
So I say all that just to say that, like, I think, you know, as we spend the next, you know, 40 minutes or so talking about some of the biggest merits decisions, you know, I do think that it's increasingly incumbent upon all of us when we talk about the Supreme Court to yes, talk about the merits decisions, but not to the exclusion, right, of the other important stuff that's happening on the shadow docket, just because there are ways in which those cases, especially as we ramp up to the election this fall, right, could be just as important. Even if they don't produce the same kind of lengthy, reasoned opinions that give folks like you and me so much fodder.
Yeah. Although, you know, even then in the, you know, the Wisconsin election case, I was a part of that case, disclaimer. You know, even there though, you did have the Supreme Court producing opinions. You know, you're starting to see more opinions, written opinions, precedential opinions or dissents coming out of the shadow docket. You know, look, some of this obvious, and we are not the first to point this out by any means, but I mean, what you're seeing from the U.S. Solicitor General's office right now with the number of stay motions being filed is definitely unprecedented. And you can talk about why that's happening or how that's happening in nationwide injunctions and Trump administration and, you know, whatever. The bottom line is it's happening. And then seeing how the court has been processing that, I think is part of the story about this term. And I guess for me, the other big overarching theme just before we get into the cases is this really felt like it was a term where the Roberts Court, of course, is coming into its own. It is the Chief Justice's court now.
I was going to say, emphasis on Roberts, right? That, you know, that, I mean, yes, I mean, this is, you know, this is not the first term where we've had the new solidified, you know, 5 justice conservative majority, but man, I mean, Scott, I am hard pressed, especially if you include the shadow docket, I am really hard pressed to think of a single term in the entire history of the Supreme Court where, I mean, maybe except for when John Marshall was running everything, where a single justice had so much influence just up and down the docket, right? I mean, the chief is in the majority in all but 2 of the 53 argued cases, right? He's in the majority of all but one of the 5-4 cases, and that includes the shadow docket. All 11 5-4 shadow docket orders, the chief is in the majority. And it's not just that he's in the majority in all these cases, it's that he's writing either the majority opinion or the central concurrence, right, in a disproportionate number of these cases, from DACA to, June Medical to the 2 Trump financial records cases. And, love him or hate him, it is a remarkable performance by any metric for a single justice in any term. And, Scott, I think it absolutely drives home that this is the Roberts court now in every possible way. And then on the big, divisive cases, every once in a while it would be Gorsuch who's the median, right? But it's really the chief who's going to be the median more often than not.
Yeah, and just to really hammer home the point, I mean, not only is it, the Chief Justice is now the median just, but in the modern court, as you were alluding to, we've never had the Chief Justice being the median vote in this way. I mean, you think about, something like the Marshall Court, even the Warren Court. I mean, a lot of the decisions there were a product of almost uniformity. I mean, of course, by the Warren Court, you had some divided decisions, but, you had plenty that weren't. And so the label Marshall Court or Taney Court or Warren Court, it really did feel like, oh yeah, it was that court, and we're just going to refer to it in the era of the Chief Justice as the shorthand designation for what was happening. The modern court, the Burger Court, the Rehnquist Court, now the Roberts Court, your median justices were, Justice Powell, Justice O'Connor, Justice Kennedy, they of course were not the Chief Justice. And so now you have the Chief Justice who's in the majority the most, and importantly gets to assign the opinions based on the customs of the Supreme Court. And that confluence of opinion, assignment, and being the most senior justice by designation of being the chief, combined with the fact that he is, in many cases, the median justice, leads to that. And so it'll be interesting to see going forward, if he is going to continue to assign himself many of these major opinions, and I assume he would, but we definitely saw that front and center in this term. So I suppose, go ahead. Yeah.
We've been agreeing and way too much. So should we pick some cases and start?
Yeah, let's get it. So to break up what I just said, let's just start with Bostock, because that was one of the biggest cases of the term, if not the biggest case. And there, the Chief Justice did not assign the opinion to himself. Justice Gorsuch wrote the majority opinion there in a 6-3 decision where the court interpreted Title VII, the words discrimination on the basis of sex, to include both sexual orientation and gender identity. And there's been a ton of commentary on this, and so I'm not going to try to go through every aspect of the case, and we don't have the time tonight to go do that in many cases. But just to point out, I think, a few things. There's this obviously fascinating debate between the majority opinion and the dissenting opinions about what exactly is textualism. And I think the easiest way to understand what's going on there, Justice Kavanaugh, in the middle of his dissent, he talks about the distinction between literal meaning and ordinary meaning. And I think that's a lot of what was going on there, because it's really, you don't have a fact pattern like this case very often, where in 1964, when the statute was created, it is almost undisputed that Congress just never would have understood the term sex at that time to include sexual orientation and gender identity, to the point that Judge Posner, in a Seventh Circuit opinion on this issue, said, look, we as judges should just be honest and upfront about what we're doing here. We are updating the statute, and there's no way 1964's Congress would have ever thought that that's what they were doing. But you have the majority opinion by Justice Gorsuch saying, well, it is inherent in sexual orientation and gender identity that you have to have a starting point of one's sex, and therefore it is part of that term, so that discrimination on the basis of sexual orientation or gender identity would be sexual discrimination, or discrimination on the basis of sex. Now, the dissenting opinions say, well, no, that's obviously not what's going on under ordinary meaning. They can come up with various hypotheticals to show that we know intuitively that though these are different concepts, and maybe they're related, but in a statute that's supposed to have causation on that factor, and Justice Alito in particular highlighted this a bunch, you need to have a closer connection than just related, or else there'll be all sorts of potential sweeping ramifications for this, which we can get into in a little bit. And the final thing I'd say about Bostock, Justice Kavanaugh flagged this very interesting part where he said, well, look, if discrimination on the basis of sex includes sexual orientation, then what were we doing in Lawrence and Obergefell and Windsor and all these cases where, as a constitutional matter, the court was not applying, or at least it said it was not applying, heightened scrutiny? If those were all actual examples of discrimination on the basis of sex, well, then they should have had heightened scrutiny. So at least Justice Kavanaugh pointed out there was a disconnect there. But anyway, Professor Vladeck, I'd love to hear what you think were the main and biggest takeaways and debates in that case.
I mean, Scott, I certainly agree with the framing that there's a really interesting and rich debate about what kind of textualism we mean. And Tara Lee Grove actually has a really interesting essay in the forthcoming Supreme Court issue, the Harvard Law Review, devoted entirely to the question of which textualism. I will say, I mean, I don't think this will shock either you or the folks who have had me in class who are subjecting themselves to this. I do think that it shouldn't surprise us that if Congress uses a term that is dynamic, that the dynamism of the term will necessarily alter or affect the interpretation as time goes on. We can fight about whether sex should be conceived of as a dynamic term. But if Congress says unusual, right, or if the Constitution says unusual, I think we all agree, yes, unusual is actually clearly a reference to evolving understandings of what's usual, and not just what was unusual in 1791. Well, I say that all of us agree, and maybe Gorsuch doesn't. But so that's sort of where I start with Bostock. On the point about Lawrence and Obergefell and all of the similar cases, I mean, so first of all, I think, of course, the critique that Justice Scalia launches at Justice Kennedy in both of those cases is that the court was applying heightened scrutiny, it just wasn't admitting it. Second, of course, the Obama administration argued in Windsor that the court should be applying heightened scrutiny to discrimination on the basis of sexual orientation. And so I actually think it is perfectly intellectually honest for progressives, right, to suggest that, yes, all along this should have been, understood as both a statutory and constitutional dynamic. Of course, Scott, there's a very different question about how the court will interpret the Equal Protection Clause, right, versus how the court will act as the agent of the legislature when interpreting what Congress did in 1964. And I guess I'll just go on a limb and say I do not read Bostock as any kind of sign that there are 5+ votes to start applying intermediate scrutiny to all sex-based classification under the Equal Protection Clause. And I think, neither Justice Gorsuch nor the Chief are going to have any trouble distinguishing the statutory context from the constitutional one.
And that was going to be one. Yeah, go ahead.
No, please.
Oh no, because I was going to ask you, do you think going forward? I mean, it seems that it's very sympathetic, I think, in the employment context to say, yeah, look, okay, workers should have protections. But as you just said, and Justice Alito pointed out, there are a whole slew of other statutes that this could apply to. And
I think Scott, Title IX is one of the big ones, right? I mean, I think, I don't think this is going to be a big deal on the equal protection side. But I do think that fleshing out how Bostock affects, because Title IX is a big deal, not just because sex is such a central part of Title IX, but because everyone sort of understands that Title IX was modeled on Title VI. Right. And so, I think the lower courts are going to have a lot of work to do in sorting out how Bostock sort of cuts across. But the other thing is, and I suspect you don't disagree on this, I also think it's critical that Justice Gorsuch went out of his way to note that the court was not deciding how potential religious exemptions would apply and would potentially mitigate against or militate against Title VII claim in this context. And I think that's, this is both, I think, a segue to some of the other big cases from the term, but also, I think, a harbinger of things to come, that, this is a court that may very well issue decisions on sort of pure discrimination claims that actually look somewhat progressive, but with enormous religious exemptions that are going to be heavily criticized, at least by progressives, right, as sort of opening the door to discrimination in the guise of religious and moral beliefs.
Well, look, that's a perfect segue. Let's talk about Guadalupe and then Little Sisters. Let's start with Guadalupe because I think that's obviously the biggest transition there, where the court in the Our Lady of Guadalupe case held. It was another case following on the what is it? The ministerial exception, and what does that entail? And the ministerial exception is a doctrine that says if you're talking about a religion and its ministers, and we will leave that term undefined for the current time because that is what the case was all about. Federal law cannot come in and tell religions how they must operate in choosing their ministers. In other words, you have an exemption from federal employment laws. And so, to Professor Vladeck's point, if Bostock and other cases were to say, here's the general applicable law, and it broadly applies, but then there are a series of exceptions, including here the ministerial exception, well, then that tempers or alters the balance of what the protection would be. And in Guadalupe, the court said that even teachers who themselves were not practicing that particular religion, the fact that they were teachers who themselves were in fact teaching religion in religious schools, that was enough to be covered by the ministerial exception, which meant that federal employment laws did not apply when they were fired. And so to your point, Professor, this was an example of when the court with one hand is saying, here, there are these broad laws, it's also saying, yeah, but we need to be careful about these certain areas that should have protections and exceptions.
Yeah, I mean, so let me start with that. I mean, Scott, I won't tell anyone to call me Steve. It's really fine.
Okay.
But so there's a trio, right, of very significant religion cases that the court decides. Right, there's Guadalupe, there's Little Sisters, and there's Espinoza. Religion. I'll just say, I mean, I always struggle, right, with the religion cases because I think that first of all, I don't think they split in obvious ways. Second, I think there's a real tension, at least in some of the cases, between, on the one hand, protecting free exercise, and on the other hand, avoiding establishment,
Yes.
right? And sort of splitting that difference, I think, is actually very hard to do with categorical rules as opposed to sort of more case-specific factors. That's more Espinoza. What struck me about Guadalupe was, I think everyone agrees that Title VII shouldn't apply to ministers. And everyone agrees that Title VII should apply to janitors, right? And the question is, where between janitors and ministers, right, does the free exercise clause prevent Congress from regulating? And I guess, my reaction is that I think if Title VII does apply to janitors, right, then you're saying that it's not just about religious employers, period, right, that there actually has to be some kind of functional test. And I just, once you concede that it has to be a functional test, not a formal one, I guess it's not clear to me why teachers of secular subjects, right, who have no religious responsibilities and no religious sort of curricular commitments, right, fall on the minister side as opposed to the janitor side. But again, I think it's worth stressing, we're fighting over a relatively narrow slice of real estate, at least legally, although practically, of course, that's a huge difference given how many religious school teachers of secular subjects there are in America.
Yeah, of course. I mean, some of this also, coming at it from analyzing litigation risk, depending how you set these rules,
right.
Religions and churches, of course, could say, well, and I think some of the hypotheticals at oral argument were going down this road, okay, well, what if this person has to do 3 minutes of religious instruction a week as part of their job? Does that qualify? And I'll tell you, I mean, the oral argument, there were tough hypotheticals asked of both sides, and there didn't seem to be a clear-cut test. Now here, I mean, the court, this was a 7-2 decision. Justices Breyer and Kagan joined the majority opinion. And so, this was not one of the cases that was viewed as being the 5-4 hot button split issues that the court confronted here. But this is obviously is a very important, I think, entree into the religion clauses and what the Roberts Court's going to do with them.
Yeah, I mean, so I'm of the view, and I'm curious, Scott, if you agree, that like all three of these cases are really appetizers for the most important religious liberty case the court has heard in 30 years, which it's hearing next term, which is Fulton versus City of Philadelphia, right? Because, to me, I mean, I have issues with all three of them, not surprisingly, and if time permitted, I'd be happy to sort of walk through where I get off the bus. Although I do think it's telling that Breyer and Kagan are only in the dissent in one of them, right? Only in, I think, Espinoza.
Yeah.
Right. But the court has, we've seen this going on for years, where the court is trying to walk back from Justice Scalia's remarkably broad endorsement of secular intervention, right, of secular interference in Employment Division versus Smith. And I think, what is becoming increasingly clear to me is that the walk back becomes increasingly disingenuous at a point, so long as Smith is still on the books, right? And it seems like the real question is, do we believe in Smith or not? And just for the folks who don't know, right, Employment Division versus Smith is a incredibly controversial and incredibly important 1990 case. It's the peyote case, about whether the free exercise clause has anything to say about state or federal laws of general applicability that incidentally burden religion, right? That do not have as their goal the burden of religious practice, but that have the effect of burdening religious practice. And the Supreme Court in Smith says no, that as long as they're of general applicability and secular in origin and intent, right, the free exercise clause does not, they don't offend the free exercise clause. And I think a lot of what we've been seeing in the last few years is a court that is increasingly hostile to that idea, chipping away at it within the framework in which that's still the law. And, Fulton, as you know, I mean, first of all, it's really confusing because there are two cases called Fulton on the docket for next term. One is Fulton versus City of Chicago, one's Fulton versus City of Philadelphia. I got them totally backwards myself. The lesser one's the one that's being argued the same day as my case. But in Fulton versus City of Philadelphia, one of the questions presented is, should the court overrule Smith? And I actually think that is like a potentially watershed moment, right, for the court's religious liberty jurisprudence, in a way in which I thought all three cases this term were really just, sort of not sideshows, because these are important disputes, but like lead up, right, build up, not the main event.
Yeah, and so take Little Sisters, for instance. I mean, this is a case that had been up to the court. This was the case about the nun group who is suing to say that it should have an exemption from the Affordable Care Act, administrative regulations imposing a contraceptive mandate. And it had been up to the court. The first time around, in an odd ruling that was not really a ruling, the court requested briefing from both sides saying, hey, is there a middle ground you can fix this? And both sides said, yeah, we think we can. And so then it vacated all the opinions, sent it back to the lower courts, directing the parties to try to come up with something. They tried, they failed to come up with a fix. And so then the litigation continued. Of course, then you had the Trump administration coming in. So the Trump administration creates a new exemption. And then the states of New Jersey and Pennsylvania, I think.
Yeah, Pennsylvania.
Yeah, sue saying you can't create that exemption. So this gets back up to the Supreme Court. And the Supreme Court this term says the executive branch does have the delegated authority in the Affordable Care Act to create an exemption like this, but it doesn't actually resolve the entire case because there's still a pending Administrative Procedure Act claim, and there were side opinion. There was a Justice Alito concurrence, there was a Justice Kagan concurrence. They were both arguing over what that our APA arbitrary capricious claim was going to be like. It's amazing to me that this case is taken this number of years to be resolved. But so as far as the religion doctrines go, this decision left open the religious the RFRA aspect, and so there wasn't a definitive ruling there. There was a lot of buildup in this case, and then the actual ruling wasn't that broad.
Yeah, I mean, I agree. And not only was it not that broad, right? But I don't see anything in the ruling that's going to stop a hypothetical Biden administration from coming in on day one, axing the Trump exemption, and then we're back to where we started with Obama, right? I mean, assuming the ACA is still around, which is its own. we can get to that when we get to.
That's next term. You're gonna have to come back next year.
Next term. This is just sort of, jumping ahead a bit. I mean, one of the things that's remarkable about next term is it's very possible that like half of the big cases the court already has lined up for next term will be moot, right, by the time they actually get around to deciding that. But that's not here nor there. Can we talk a bit about what kind of term Trump had? Because I think that's actually another interesting, thinking about sort of DACA in particular is like one of the flagship Trump cases of the term. And of course, the two financial records cases. It strikes me that the administration actually had a pretty good term on sort of the lower profile cases, right? But a really bad term on the high profile cases that, right, that between, because, you know, they're involved, Little Sisters obviously is a win for the administration. Espinoza and Guadalupe, they're amici in support of the positions, right? Bostock is a loss, right? DACA is a big loss, right? And I think the financial records cases are also losses, although not necessarily the full bore losses that the progressives wanted. But I guess I'm curious, you know, to what extent do you think the sort of the Trump shadow and what others might call Trump derangement syndrome, right, was hovering over the court last term?
Well, I mean, I think the first thing I'd say is if you go read those the Trump financial record cases, Mazars and Vance, I mean, you have a court grappling with, and you saw this at oral argument too, understanding that these issues are about the presidency, and there will very soon be a day that there will be a different president, and there will be many other presidents, and that the issues that the court was confronting really did apply to those bigger things. And also the historical analysis there. I mean, it obviously goes way back to, you know, Burr and Jefferson.
Aaron Burr.
Yeah, everyone loves Aaron Burr.
You know the chief was champing at the bit to talk about Aaron Burr.
It's, you know, you could tell that the court understood the gravity of it. And I think that's also why that in both of those decisions, there was somewhat of an unsatisfactory resolution because there wasn't a resolution, and then even the test that the court said should apply was more of a, well, let's come up with a balancing test but put a thumb on the scale here or maybe there. And I think a lot of the concurring opinions were saying, look, how this plays out in future cases is going to dictate whether, you know, this test is actually meaningful and can provide some, you know, protect, you know, Justice Kavanaugh, I think, said that the definite specific need test from Nixon should apply. The majority didn't say that, but the majority didn't quite rule it out. So I don't know. I thought that the Mazars case about the U.S. House trying to get the records, I think that felt like more of a win for the Trump administration. In the Vance case about the state criminal proceedings, that didn't feel as much that way. And I know that case obviously is getting headlines still as it's continuing on remand.
Yeah, I mean, I guess I certainly agree with the relative assessment, right? That Mazars was less bad for the administration than Vance, which was, you know, I think one step short of a total wipeout for Trump. I mean, I think the only thing he didn't lose was that the chief agrees to remand for Trump to raise additional claims that have already been rejected on remand by Judge Marrero. In Mazars, you know, Scott, I guess it depends on what to be, right? I don't mean you, right? It depends on what one's metric is, right? By which, what's the yardstick in Mazars? Because, you know, think about what was out there. You had this panel opinion by Judge Griffith that disputes over congressional subpoenas are per se non-justiciable, right? Which we now know from Joan Biskupik, Justice Kavanaugh, you know, was behind the supplemental briefing order asking the parties to address that, and the court says nothing about it. You have, you know, the dissent in the DC Circuit by Judge Rao, which says Congress can never issue a subpoena like this outside of the context of a formal impeachment investigation. So you had two alternative avenues for Trump to win in Mazars that I think would have been remarkably separation of powers altering decisions.
Well, to be clear, they were swinging from the fences in both of those cases, saying, you know, the power of the presidency and absolute immunity, and they definitely didn't get that. Absolutely.
And what strikes me about the chief's opinion in Mazars, and I think this is why I see it as less of a win for Trump than I think I hear you to be saying, is that the chief says, you know, here are the 4 boxes that Congress needs to tick. But the opinion, I think, proceeds from the assumption that if Congress ticks those boxes, the subpoenas are valid. And not only valid, but judicially enforceable. And I think those two, if that's a fair reading of what the chief held, right, that Congress, if you tick the boxes, the subpoenas will be legitimate and they'll be judicially enforceable, you know, that's a pretty significant development. And I think it would empower at least a future Congress if it wanted to get more aggressive about creating some kind of procedure for expediting these disputes, since they tend to be mooted by the time they're ever finally resolved.
Yeah. Well, I mean, to me, no, go ahead.
No, please.
No, On the House side too, I mean, this is another weird wrinkle in this, that everyone said, hey, we're not invoking the impeachment power, or we're not investigating this for impeachment. And there were reasons it played out that way as a factual or procedural matter. But I think there's an undercurrent in there that, well, if this had been done pursuant to impeachment investigation, then maybe that would be a different scenario. I'm not sure if that would actually play out that way, but it's interesting that the House did in fact go through with impeachment proceedings, but they just didn't tie these subpoenas directly to that impeachment proceeding.
Well, I think, Scott, that was strategic. I mean, I think it's the same reason why Doug Letter, during the oral argument, when asked for a limiting principle, refused to provide one, right? It's not because he wasn't prepared. It's because the House's position, Trump is not the only person whose lawyers were swinging for the fences. And so, that's why I think, in the short term, Mazars looks like a win for Trump, because there's no way these subpoenas are going to be enforced in time, right? And I don't mean that as a prediction about the election. Like, forget who's president in January. It's a different House in January, right? And so at the very least, they'd have to start over by reissuing the subpoenas. But I just think that, compared to what we could have seen, what we could have gotten, it just seems like in the long term, even if Trump doesn't lose these, even if Trump never has to comply with one of these subpoenas from Congress, right? The chief, to me, has really given Congress wind at its back that it didn't have before to try to enforce future subpoenas against the executive branch. Whether that's a Republican Congress against a Democratic executive branch or vice versa is, of course, why this case is so interesting and why I don't think it was 5-4. Should we say a bit about DACA?
Yeah, I think we should. Take it away.
So I think, speaking of the chief, right? I mean, I think the two opinions that I think of his that probably received the most attention because of their significance to the result, as opposed to Mazars and Vance, where he's writing at least nominally for 7 justices-ish, right, are DACA and June Medical. And, in DACA, I mean, I don't know about you, I was struck by how much the chief's opinion in the DACA case sounded a heck of a lot like the chief's opinion in the census citizenship case from the previous term.
Absolutely.
Where it's like, dear Trump administration, you can do this. This thing you wanted to do, you have the power to do it, but you got to do it the right way. And you got to turn square corners, and you have to not misrepresent to the public why you're doing what you're doing. And I guess, I realize this is going to get me in trouble in this audience. But what surprises me about that result is not that the chief said that, but that it provoked 4 dissents, right? That it seems to me that we ought not to be that troubled by the notion that, as the chief says, the government has to turn square corners. And I suspect that you and I don't see eye to eye on this one.
Well, I think some of the difficulty here in the DACA case, which, first of all, I agree completely with you that this felt a lot like the census case from last term, in that the violation, the headline is, court rules against Trump on DACA, or court rules against Trump on census. And the actual holding of the case is a very narrow technical Administrative Procedure Act violation. And there's language in that DACA opinion where the court says, DACA is not a mere non-enforcement policy, and that's why it's judicially reviewable. And there are various, aspects of the court recognizing some of the positions that the Trump administration was saying about DACA. But then it says at the end, or not the end, but in the concluding portion of the opinion, it says, well, you didn't analyze all of your options. You just rescinded the whole policy instead of saying, well, we could rescind the benefits, but we're not going to rescind the non-enforcement, the non-deportation part. And the court said, look, to be clear, we're not saying that that's how it had to play out. It's just the administration, the agency had to grapple with and give an explanation as to why it was not doing that. Now, one of Justice Thomas in dissent points out, he says, well, look, in his opinion, the program was unlawful. And if it was unlawful, then why would you be having this overlay of an APA procedure to repeal an unlawful administrative action? So I think that's where at least Justice Thomas's position was coming from. Justice Kavanaugh, in his dissenting opinion, seemed to be having a different take on another esoteric administrative law doctrine, which we can get into if you want to. But the point being that in a lot of ways, this was a kind of a wonky administrative law case, even though it obviously was about a profound policy in DACA.
Well, and I think, and to me, what I come away from is especially for law students, administrative law matters.
Yes, it really does.
Right? And it matters not just because like it provides an excuse for the court to strike down something they don't like. I mean, I actually think, I don't know, Scott, where the chief would be, right, if really pushed to decide up or down on the legality of DACA. Right? He does a very good job of not tipping his hand on that, right, in the opinion. But I think, especially for him, the sort of the procedural formalities are a powerful ground to rest on the theory that if the government's going to do something like this that's going to be controversial and that's going to have these impacts, right, it ought to actually do so with full candor, right, and with full sort of disclosure. And I guess, that's a principle I'm comfortable with, even if it takes a little bit of wrangling to extract that from the court's modern administrative law doctrine. I think a lot of folks really overread the chief's opinion in multiple directions, right? I mean, there's this whole thing about John Yoo going to the White House and telling them how the DACA opinion allows them to do whatever the heck they want to do, right? Versus progressives saying, look, DACA's great. And I think, right, this is, we talk about the term the chief had. I mean, this is to me the sort of the epitome of it. It's the chief, sort of finding the only way out is through. And he does this hyper-technical administrative law decision, to get through this one, where if the administration really wanted to rescind DACA the right way, right, nothing in the chief's opinion would stop them.
Yeah, I mean, in fact, the administration since, at least, the acting DHS secretary has...
The putative acting DHS secretary.
The putative acting DHS secretary has said that the DACA, like, new applications will not be accepted. So they didn't, like, go full on saying it's, okay, we're doing it the right way and we're repealing it all now, but it was almost like a first step towards that. So in other words, stay tuned on all of it.
Yep.
And of course, with the, presidential election coming up, like Little Sisters, this is another set of issues that, there has not been a definitive resolution on in this term. And it is almost certain that you will not see a definitive resolution of these issues, at least for another year or two, if you even get it then.
Can I suggest that we quickly do abortion and guns and then throw it open to questions?
Yeah, nothing controversial.
No.
Guns will be easy. Guns will be easy because in the New York. Go ahead. You want to?
Please. I think guns are easy and yet not. But start with New York.
Yeah, well, okay, fair. So it's easy in the sense of what happened, which was the court found a lawsuit challenging a New York gun restriction to be moot, and it therefore vacated the lower court decisions and said,
Munsingware.
We're Munsingware vacater, but we're going to remand and we're going to see maybe you could replete some claims and have a damages claim, but we're not going to say that, and we're just going to kick this back down. And so you did not get a Second Amendment ruling on the merits about that New York law. Now, interestingly, you have Justice Kavanaugh saying, I agree that the case is moot. However, I also agree with the three-justice dissent in pointing out criticisms of how the lower courts are applying Keller and McDonald, the two big Second Amendment cases, and then we should take a case soon to actually be able to reach the merits of these Second Amendment claims. Now, of course, the court then had whatever it was, 8 or 10 cases in the pipeline ready for them to take, and they denied cert in all of them over the dissents of Justices Thomas and Kavanaugh, which surprised a lot of court watchers.
So that's the piece that I find remarkable, right? Which is, I think it was absolutely correct that the New York case was moot. I mean, I think, there's no doubt in my mind that the New York legislature mooted the case on purpose, but that's never stopped the court. Like, motive has not been part of mootness analysis in the past, and I'm not sure we want a world where it is, right? I would have thought, right, that if there were, there were clearly, to me, Scott, right, 4 votes to take up any one of those 8 or 9 cases, a couple of which I think the Graywall case out of New Jersey, right, really raised, I think, some core questions that would have allowed the court to provide guidance about the standard of review for Second Amendment claims, about the Second Amendment's applicability to, say, like felon in possession, et cetera, all that, to public carry, right? I mean, all this stuff.
Yep.
And, this is where, again, I want to sort of go back to Joan Biskupic's 4-part reporting, for CNN, because one of the things that Joan reported that I don't think anyone really suspected was that the break sign was coming from the chief. right? That the reason, not just that the chief was not in a hurry to grant cert, but that maybe at least one of the other conservative justices was wary of the chief being, for lack of a better word, squishy, right? And so there was sort of these defensive denials of cert, where 4 justices thought that there were plenty of worthy cases, but just weren't convinced that they had the 5th vote on the merits. And what I find interesting about that is that wasn't where they were when they granted the New York case. And so what would have changed between when they granted the New York case and when they dumped the New York case to lead them to think all of a sudden that the chief is soft? That's the part that the Jones reporting doesn't really illuminate.
Yeah, and then of course, we're back to your point about the shadow docket, that since the court doesn't have to give reasons about why it's denying cert, and I mean, if it had to give reasons of why it's denying cert, there'd be all sorts of more work that the justices and the clerks have to do because they deny so many cases. Sorry. No, so Joan Biskupic's reporting, though, I mean, a lot of this too is, unparalleled, unprecedented, whatever term you want to use. It is very, very rare that you would have that level of public insight. And that itself is, you call it problematic for the institution and other thing. But, I don't know if you have a thought or a take. It's certainly juicy as, an outside, a practitioner and trying to understand the court and why things are happening that way. I'm not sure it's very good for the court itself, though.
So I really struggle with this, Scott, and I think I struggle with this partly because, I often wear sort of 2 different hats, right? The sort of the law professor versus the SCOTUS advocate. I am less troubled in the abstract by the court leaking a little, right? Especially if it's leaking after the fact. Like, it's not it would be one thing if we found out like 2 days before a decision what the decision was. I think that would be, an enormous scandal in the sort of staid world of the Supreme Court. Having an insight into some of the inside baseball, I guess, I'm not quite willing to say that the Chief Justice ought to resign over this, as someone we both know argued in an op-ed in Newsweek. I will just say that, first of all, I feel quite confident that the relevant leakers here are not clerks, right? Given the professional suicide that would result if anyone found out that they had leaked. I suspect it's justices leaking. And, and then the question is why, right? Like why, is the goal to embarrass the chief? Is the goal to, sort of try to create some kind of narrative? And that's where I think it gets really messy to me. Is like, I'm less worried about like, is this bad for the court than like, who's doing it and why? Like, cui bono, who benefits? But, I'll just say, I do think that the court's going to continue to have plenty of attractive candidates for gun cases. You probably saw about a couple of weeks ago, a 9th Circuit panel. This is not the 9th Circuit I clerked on. Right, struck down California's large capacity magazine ban as a violation of the Second Amendment. That's cert worthy on its own. So I think this is probably just a matter of when, not if. But I thought it was very interesting that it wasn't right away.
I was just saying, I know, because, we've got questions lining up and we have to talk. See, this is how big of a turn. We're going to talk about June Medical, the Louisiana abortion case. But before we talk about that and then take questions, I just got to talk about the cases we're not even going to touch on that much. The CFPB director and the separation of powers issues there. McGirt versus Oklahoma. Ramos. Yeah, the faithless electors cake. Yeah. There are plenty of things that we could talk about. We're happy to do it, and some of the question and answer before we open up for Q&A. June Medical, it's getting a lot of attention right now in the lower courts and the U.S. Solicitor General's position on what is the controlling opinion in June Medical. It was a 4-1-4 decision where Chief Justice Roberts wrote a concurrence in the judgment, and you don't see this very often, where he said, I dissented in this prior case. I continue to believe that case was decided wrongly. But as a matter of stare decisis, I must apply that ruling. And
it's the second time he's done it. Were you counsel in Moore?
I was counsel in Moore, and I was also counsel in Holman's Health versus Hellerstedt.
Right. Because Moore's the only other time he did that, right? Moore versus Texas was the only other case where he dissents in round 1 and then concurs in round 2 because he thinks that in that case, the Texas Court of Criminal Appeals hadn't been faithful to the court's mandate.
Yeah. And so, but I guess for So that itself is just, okay, that's a unique, fairly unique situation. But bigger picture doctrinally is, well, okay, what is the constitutional test in abortion cases now? And the Chief Justice opinion says, well, there was this kind of balancing of burdens and benefits in Whole Woman's Health versus Hellerstedt. That actually wasn't the doctrinal test. The doctrinal test is still the Casey, Planned Parenthood versus Casey test. And you really only look at the benefits in assessing that threshold, call it rational basis or legitimate purpose test. And once you get past that, though, then you just ask, is there a substantial obstacle to obtain an abortion? Now, and we haven't even got to why there's a little bit of a debate about, well, is that the holding of the court or not? Take it away.
I mean, it doesn't matter because the lower courts are assuming it is, right? I mean, we've already seen, I think, the Eighth Circuit vacated and remanded an injunction against Arkansas's fetal heartbeat law, right, on the ground that the district court had applied Whole Woman's Health. And the Chief's opinion makes clear that Whole Woman's Health is not really the relevant analytical framework anymore. It's really a remarkable move by the Chief because by joining in the judgment, right, he's actually able to sort of, in one fell swoop, effectively get rid of Whole Woman's Health while also slapping down the Fifth Circuit for trying to do it first, right? Like it's a remarkable sort of kung fu where he says, I don't actually think that part of Whole Woman's Health is controlling or should be, but because the Fifth Circuit didn't follow Whole Woman's Health, I'm agreeing with the 4 progressive justices that we should, reverse their decision below. And I guess I think that it's his prerogative. It's a very strange approach to stare decisis. I mean, much like the joint opinion in Casey, where the court says stare decisis, we're reaffirming Roe, even while we completely tear out the heart of the Roe test and replace it with this undue burden test. It's a very similar move, and it's just yet further evidence, I think, that the court just goes to all of these analytically difficult, if not convoluted, gymnastics in abortion cases in ways that we don't necessarily see in every single case in a different field.
I think that is a perfect point to turn to the Q&A. I don't know, moderators, if you just want us to, I can see the question and answer queue, or I don't know if you all want to pick out certain questions for us. Either way.
Yeah, I'm happy to pose them to you guys. I think that we thoroughly answered the question about New York State and Rifle Association. So I think we can just go ahead and skip that one. I would like to first take us to the Mazars question. So I'll go ahead and read that for everybody. Do you think a different posture would have affected the court's approach to Trump versus Mazars? For instance, if Congress had sought enforcement of a subpoena directly against the president rather than a third party, would the court have issued a similar opinion? Or do you think that the court might dismiss on justiciability or cause of action grounds, as some DC Circuit judges have held in McGann?
But I think it's a great question. And so, as 2 DC Circuit judges have held twice, having been reversed en banc the first time, and I suspect about to be reversed en banc the second time. So obviously the posture is a factual distinction, where, in Mazars, it's the president suing as the plaintiff to prevent a third party from complying with a subpoena. It's not necessarily, I have no problem with the president standing or with the cause of action that he's invoking, the non-statutory cause of action he's invoking in both cases. I just think it has to go both ways, right? And I actually think that, the fact that the chief writes the entire opinion of Mazars without saying a word about justiciability, when the whole premise of Judge Griffith's since vacated original panel opinion in McGann was that these disputes are per se non-justiciable, not just because Congress lacks standing, to me suggests that the posture probably didn't matter. Of course, just today, we had Judge Griffith on his last day on the DC Circuit saying, all right, fine. So it's justiciable. But the House doesn't have a cause of action, which, it's almost like whack-a-mole at this point. Judge Griffith, of course, is uniquely situated to have this view because he was the longtime Senate legal counsel before he was a DC Circuit judge. So he has some strong views about the very different powers of the Senate versus the House. I guess I just, the cause of action issue might be an off-ramp for the court, but I just think that this is a court that has never balked at implied causes of action in the sort of prospective relief context, the way that it has balked at the issue in the retrospective relief context. For example, in Hernandez, a case from last time that we didn't talk about, but the lawyer in that case was fantastic. So this leads me to think that there probably are 2, 3, maybe even 4 votes for the cause of action holding in McGahn, but I doubt 5. But that the more important point that I think Congress has figured out and is still trying to, and is just trying to operationalize, is how to sort of speed up this whole process. And so I actually think it is almost inevitable that in a scenario where there is one party Democratic rule in Washington next year, and who knows if that's going to happen, one of the bills that we see is a purely procedural bill to create some kind of express cause of action and sort of subpoena enforcement mechanism, where courts would actually be, basically not required, but strongly encouraged to resolve these cases a lot faster. And where Congress would do its best to sort of remove all of the procedural obstacles. Because what we've seen so much from this administration is just how much the executive branch can win these cases by delay, and win them by default and by inertia. And I think that, like, even if the Supreme Court ends up getting a chance to endorse some of that, Congress can fix much of that. And I suspect that, the next time there's either one party rule or, say, split rule in the House and the Senate, but a Democratic president where there's enough bipartisan support, this is going to be all mooted by statute. That might also, Seth, that might be a good segue also to the court packing question.
Sure, absolutely. So the question, for those of you who cannot see it, is if Biden wins in November, what do you think the odds of court packing are?
0. I'm curious if Scott feels differently, but so I think we should be clear what we mean by court packing, right? Because this term is bandied about a lot, and I think people use it to mean different things. So if it's about the Supreme Court and only the Supreme Court, and whether the Democrats are going to add seats to the Supreme Court, I think there will be a lot of pressure from the left wing of the Democratic Party for Biden and Congress to do that. But I think there will be nowhere near the kind of unanimity that it would take, given what would be, I think, absolutely consistent, uniform opposition by Republicans. And frankly, this may shock you, but that's right. Like, court packing, at least for the Supreme Court, to me is just, it is the surest way to destroy the court, which of course is, I think, what some Democrats support court packing because they know that and that's what they want. Some Democrats support court packing because they don't appreciate that. But I think that there's, the president's efforts to portray Biden as a socialist, left-wing radical notwithstanding, Biden is actually much more, I think, of a moderate than many Democrats would like. And I think this would be one of the areas where that absolutely shows up. Whether that extends to the lower courts, I think, is a different conversation and frankly comes with very different implications. I mean, Congress has changed the size of the lower courts, as Scott knows well, far more often than the size of the Supreme Court, which it hasn't touched in 151 years. So if it's just the Supreme Court, I think the odds are just about 0. If it's adding seats to the lower courts, then I think it's a different conversation. And frankly, I think a less fraught one.
I think all of that, if I'm, understanding the math and the procedural mechanism, I think all of it would require probably the Democrats winning the Senate and then also blowing up the filibuster, the legislative filibuster.
For ordinary legislation, yeah.
For ordinary legislation. So you'd have to clear that hurdle first. And there are some Democrats, I think Senator Manchin, saying that he wouldn't do that. Now, look, whether that would happen or not, I don't know. And then you'd have to, after blowing up the legislative filibuster, then use it in that particular way, which is to say, there would be a series of steps that have to do it. But I agree with the professor that it would be, it would change the institution of the court in a very, very negative way. Part of it is the rules are set, and maybe I've seen proposals about trying to have staggered terms going forward and changing the rules prospectively, but to do that where it wouldn't be, having staggered terms eventually, but it'd rather be benefiting the sitting president, no matter whatever party they were, that would alter the court in a very negative.
Because it would be 11 seats tomorrow and it would be 37 seats in 5 years, right? And then it's not a Supreme Court. And so, I think this is a perfect illustration of what is often a caricature of Biden, right? That, I think Biden's not the extremist that a lot of the sort of, especially the folks who were elected in 2018 want him to be. And I think this is going to be one of the areas where that manifests if we get to a point where this is even a conversation.
Well, Professor Vladeck, you mentioned the lower courts and Trump's impact. I'm going to shamelessly plug that we have an event coming up that is solely devoted to that topic. So if y'all are interested in that, feel free to come to that event. Moving back to substance, I would just point out we have a couple of different questions generally about qualified immunity and stare decisis. So I'll start with the qualified immunity. There are two questions. The first is, what is your take on the Supreme Court's denial of all qualified immunity cert petitions? Do you think the court will take a QI case in the next term? And then relatedly, relatedly, I got my question taken away from me. Give me 1 second. Do y'all think the emphasis on stare decisis this term played any role in the recent denial of cert, given that QI purports to have the force of statutory stare decisis?
So I have a forthcoming article on qualified immunity. So I'd love to hear Steve's views on this. Yeah, look, I think qualified immunity is one of those areas where multiple former and current members of the court have lodged significant criticisms, and many lower court judges have as well. And part of the issue, though, is, okay, if you're going to change the precedence of qualified immunity, well, what do you replace it with? And so that was, the impetus for, this forthcoming article I have. But I'm not going to talk about that anymore. I'm happy to talk about that offline separately. But yeah, I mean, I do think stare decisis, if not stare decisis that the court will never take a case, but stare decisis in a, look, before we take a case, let's make sure we have enough percolation. Let's make sure we've had all the ideas vetted, rather than just, criticizing the status quo without knowing where you're going. I mean, Steve, when the court takes a case, they don't always know where they're going to go. And sometimes they know they need to address an issue, and maybe qualified immunity is approaching that, that paradigm. But if you don't know where you're going, this is, in some ways, it's kind of like the defensive denials you were talking about with the Second Amendment. If you don't know where you're going, well, then maybe you just don't take a case.
I think that's right, Scott. And I would just add that, yes, qualified immunity is a judge-made doctrine, but the court is well aware of what's going on in Congress. And, I think this is a classic example where, regardless of whether a justice is a fan or not of the court's current jurisprudence, everyone agrees that Congress can do whatever the heck it wants, right? That insofar as it's a federal common law rule that's subject to statutory supersession at Congress's pleasure. And so I think there's a very easy case to be made that the court should at least wait to see what comes of the current reform conversation, which very well may culminate as early as next February or March. So I think that's a big part of what's going on. Whether the court will, if the legislative reform effort fails, Scott, would the court then turn around and say, all right, well, maybe now we should step back in? That's why I would never say never, right? But just that I think that, I think part of what's going on here is also waiting for Congress. Seth, I saw you want to cut out. Can I just say one thing about the telephonic arguments? Because I saw a question about that, and I'm curious for Scott's reaction.
Oh, I actually meant just no new questions. If y'all are good to finish up with the remaining four, I'm happy. I just wanted to respect y'all's time.
So Scott, there's a question about what we think about telephonic arguments. I'm curious for your thoughts, because as someone who may have a telephonic argument in about 6 weeks, I have some of my own.
Yeah, maybe it's the bias of having done multiple in-person arguments, but my sense is that the in-person arguments were a bit more illuminating, more useful, probably, because you'd immediately get feedback as to, okay, who really has a big concern with the case. And because customarily at the Supreme Court, the justices that are asking questions of you are the ones that are a little bit more skeptical, that they want to know, that they like, counsel, tell me, how should you win? Why should you win? Where does your argument go? And so you generally not feel.
You learn a lot just from the organic flow of the discourse.
Yes. And now in the telephonic arguments, at least the way they were structured, rather than that, every justice in seniority rank went and they had a turn to ask questions. So you had the chief would ask questions and Justice Thomas would ask questions. And you go down the line. That's very different than the traditional in-person mode where, at an argument, you may not get questions from a handful of justices. But instead, in that setup, you knew exactly who was going to be asking you the next question. As an advocate, I want that information as quickly as possible as to, I got to count to 5. How do I get to 5 to win? And if I'm getting questions from justices that I think may be with me, or maybe they don't have the information yet to know what they're supposed to be piercing about to maybe convince one of their colleagues how to vote. Yeah, that is time that I would rather have in the in-person format than the telephonic.
I couldn't agree more. I mean, I'll just use, Hernandez, which I argued in November, I think is a perfect illustration. I was aiming for Gorsuch, right? And about 8 minutes into my argument, Gorsuch comes in with a couple of questions that make it abundantly clear that my aim missed, right? And so
it happens.
But imagine a scenario where Gorsuch is the second to last person to ask questions, and where you've spent 25 minutes of the argument answering questions from justices who you just don't need, or you're not going to get. So that's one of the real changes to me, Scott. I think the other change is that it just feels so much less like a conversation.
Absolutely.
And more like a thesis defense,
yes.
Right? Where the conversation, because I think what often I think folks don't appreciate until they've been in the courtroom, and I don't think you have to do an argument, you just have to see it, is that the arguments are often the justices talking to each other through the advocates.
Yep.
And they can't really do that in this format because they can't piggyback on questions, they can't shift the conversation. In one sense, the folks who I think have been really favorable about the format have been talking about how it gives the advocates more control, because you get more control over sort of laser lock on whoever's asking a question in that moment. But I actually think in the process you have more control over your individual exchange with the justice and less control over sort of the broader mechanics of the conversation. Listen, I will show up when and where the court tells me to show up, but I think I'm not a fan of this format, and at the very least, if the court's going to keep it, I really think one of the things it ought to do is drop this idea that the arguments have to be done in an hour. Because I think what the format is slower and just takes
it absolutely
more time.
Is slower.
And so I would love to see the court just default to 40 minutes aside, so long as it's telephonic, for no other reasons than this, that you don't have all this, the chief tripping over the justices to cut them off so often. But that's just me.
Yeah, look, my guess is that the court doesn't really want to be doing it this way either, but it's the best that they can do in the circumstances. But yeah, look, I would imagine, I doubt they're going to change the practice now that they've done it before. But there's a world in which you could do a telephonic argument and not have the seniority rank, and just say the advocate gets the first 2 minutes uninterrupted, or whatever that new rule is. They're coming up with all these new rules, right. and then it can be a free-for-all after that. That's hard though when you don't have the visual cues of who's going to chime in.
I wish they'd consider Zoom. The Texas Supreme Court, and a bunch of state Supreme Courts have been doing Zoom arguments. The Ninth Circuit has been doing, it's not Zoom, but video arguments. And
I've done a Fifth Circuit oral argument. It worked very well.
It's not the same as being in the room, but at least you can see the faces and you can get some feel for are your answers landing or are they not? It's just, I feel like, Zoom would be so much better, and yet clearly they're averse to even that.
Honestly, guys, I think that seems like a pretty great place to stop. I very much appreciate both of your time. There were a couple more great questions, but I seems like a great perspective, vision into what the next term looks like. So let's stop there. Again, thank you so much for your time, both of you. And for everybody left on the call, we have another event this coming Thursday night. So if the discussion about qualified immunity piqued your interest, we'll be co-hosting with the American Constitution Society. So it should be a rare and momentous occasion indeed. Thank you so much for your time. Again, y'all have a good night. And again, if you're interested in joining the Federalist Society, be sure to message Henry Humphreys. Cool.
Thanks, Scott.
Thank you very much. Have a good evening.
Thanks, guys. Good luck. See you soon.